had our inspection from the regulators. It's gone swimmingly because we followed all the advice that you've shared with us. What might happen next?
So there's a number of different sort of follow-up actions that might come out of an inspection. Obviously, all being well, you hear nothing further, that's the end of it, or you get... Occasionally, you might get a letter or an email to say, thanks very much, we've got no further requirements from you, end of the incident. Alternatively, you might get a follow-up phone call, visit, email requesting further information. So something that you've either not been able to provide immediately, for example, if they've needed historic documents that might be stored off-site or just take a long time to collate. So you might get a request for further information. You also might, and this is likely to be a number of weeks or months after an inspection, you might get a formal invitation to attend an interview. And that would be an interview under caution. So again, under the Police and Criminal Evidence Act, to attend usually the regulator's offices, and that will most likely be for a representative of the company to attend. Again, should you get an invitation to interview, certainly if you haven't already taken legal advice, then that is a key time to take advice. You don't necessarily have to attend, and a lawyer can advise you whether or not it's in your best interests to attend that interview. You may also get a follow-up by way of a notice. So again, depending on the notice, probably is linked to the timing that you will receive a notice. If it's something that's going on site that the regulator really doesn't like and thinks is a risk of causing pollution, you might get a stop notice. You also might get a formal notice requesting particular documentation. One of the most common ones is for requesting things like waste carriers, waste registration documentation for anything that you're sending off site. That has a specific notice that's sent to you to request that information. You may get an alternative sort of compliance notice that you need to address. Again, take advice, whether that's internally or externally, as to what to do with that notice. They will often come with time limits that you need to comply with, and also just to make sure that you have that information and that you are able to hand over or to carry out the request that's been made of you. If you're a permitted site, for example, if you have an environmental permit and the inspector has noted a breach of that environmental permit, you will, if you haven't already had it at the time of the inspection, you will subsequently be provided with the record of inspection, the CAR form, and that will have noted on it what the breach was. You get effectively scored for the breaches. And that will be sent to you. I suppose the thing to note with environmental breaches is that ultimately, if you accumulate a number of breaches, then it can have an effect on your subsistence fees that you ultimately pay for the price of your permit. So you might get that, and it will say on the permit whether they are looking to take any further enforcement action, whether it's just a site warning, or whether there's no further action. Another sort of outcome from an inspection can be a written warning. So if they have identified a breach, you will get a formal sort of warning letter. You don't necessarily need to respond to that if you're in agreement with it. It can just be filed. However, it does stay on the records at the regulator. So should there be any subsequent enforcement action, they can refer back to the fact that you've had a warning letter. So if you do feel that you disagree with what's said in the letter, it's important to challenge it at that point. Otherwise, it's just going to sit on file.
Taken as read that you agree.
Exactly, yeah. If it's deemed to be a more serious breach but doesn't cross the threshold for a prosecution, or that they don't intend to prosecute for it, they may offer you what's called a formal caution, which is a bit more serious than a warning letter. They have to have enough evidence that they could prosecute you on if you weren't to accept the formal caution. But again, it sits on file. The difference being with that is that you have to sign and acknowledge the formal caution. You basically have to accept it, and that is effectively an acceptance of guilt that you've done something wrong. And again, that will almost certainly be referred to in the event of any future enforcement action, that you've already had a formal caution for a similar incident or matter. Increasingly, environmental regulators are looking to use civil sanctions in the event of environmental issues. So particularly for some things like water pollution incidents that they don't really want to prosecute for, it's maybe not in the public interest to prosecute for, or things like quite often for breaches of packaging regulations, for example, they'll use something called civil sanctions, which often are an enforcement undertaking. And what that means is you're effectively offering to the regulator that you will undertake certain actions to make sure that it doesn't happen again, to remedy any issues that have been caused, and also to donate a sum of money, usually to a local charity, something related to the incident. So, for example, if you've had a water pollution incident, you may make a donation to the local wildlife trust that manages a nearby nature reserve, something like that. Again, these are quite complex documents to negotiate. You need to make sure that you're offering a figure in the right amount, and that they won't give you guidance as to how much to donate. So you really need to take advice, get a feel for what other companies have offered in similar situations. It's not necessarily going to be cheaper. Some enforcement undertakings run to hundreds of thousands of pounds in the event of serious incidents. So it's not always a cheaper option, but it does mean that you avoid having a criminal conviction against the company's name, and it means usually you'll get a lot less media attention. Your name isn't in the press quite so much as it would be if you were in court for an incident. So that's something, again, would come a number of weeks or months, most likely, after an inspection or an incident. And then finally, the worst case scenario is that the regulator has seen something on your site that's caused serious environmental damage or is a serious breach of your permit, and they may look to instigate criminal prosecution proceedings against the business. Again, this can take years, often after the original incident or inspection, and you may not hear. You probably have some communications with the regulator in the interim, but until that decision is made by their legal team, which can be several years after the incident, you probably won't know that it's going to be prosecuted. They often don't let you know that that's what they have chosen to do. So the first you hear of it may be that a summons comes through the post.
Right.
Again, in terms of prosecution, now that the sentencing guidelines are in place and are well used by the courts, the financial implications of a prosecution are obviously huge, particularly if your business has a large turnover, because the fine will be linked to your turnover. But even at that stage, there are a number of things that can be done. There are various ways to try and bring down the financial exposure. All the way through an incident, we should be looking at mitigating factors that we can employ, like I've mentioned before, cooperating with the regulator, making sure the incident doesn't happen again, whether you need to train your members of staff in a different way to make sure that they can respond proactively to incidents, whether you may have self-reported the incident. All of that goes towards sort of chipping away at any financial penalties that might be imposed. But I mean, it goes without saying that obviously, should you get any indication that prosecution is pending or is on its way, then certainly you need to take legal advice immediately.
Yeah, absolutely. That's been really helpful. So bringing things full circle, an inspection doesn't need to be the end of the world. It can be just routine. It could be as a result of an incident. There are things you can do to safeguard the business throughout that process, and there are obviously a number of outcomes that can happen at the end of it, be that nothing, a caution or enforcement action. But it's really important, based on what you've said, to make sure you get it right and handle it well from the outset.
Absolutely.